So if you test today, you're going to be clean.
I am honestly hoping that is out of my system.
Well, we all can have hope. If you test today, are you going to be clean? See, you're already on thin. Hang on.
I'm going to say no.
You're already on thin ice with me because you were about to lie. You were trying to lie to me.
I don't think so.
And the bill for the people, right? This is Public Defenders Act, committee with my behalf of the substantial approaches.
You guys got to make sure to clear that way when transport's coming through, Mr. Lebo.
Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the time set for a bond hearing. So, Ms. James, as you remember, as you recall last week, Ms. James was ordered to go to community corrections to test.
To make a statement to the court.
Yes. Okay, go ahead.
Yes, I did use 4 days ago. And when I was placed on probation yesterday, I was being honest with my probation officer and informed her that if this test does come back positive, it would be the only one.
So if you test today, you're going to be clean.
I am honestly hoping that is out of my system.
Well, we all can have hope. If you test today, are you going to be clean? See, you're already on thin.
Hang on. I'm going to say no.
You're already on thin ice with me because you were about to lie. You were trying to lie to me. And so I'm going to ask you again. If you test today, are you going to be clean?
I don't think so.
You don't think so?
I think there will be traces.
Okay. So now you said it, but I want to make sure. When was the last time you used?
4 days ago.
4 days ago.
4 days ago.
All right. Tell you what, let's get it. We'll send you over, get a test. I'll pass it. Got to go over to community, right? Get a test.
Thank you.
Okay, thank you.
Do you know where to go?
Yeah.
And if she doesn't come back, it's a bench warrant, no bond, but go ahead. All right, let's see, who's next?
Judge Simpson is testing more than Amanda James's drug status. He is testing her credibility and willingness to follow direct court orders. Notice how he repeatedly replaces the vague phrase, "I am hoping," with a yes or no question. That is deliberate. In a bond hearing, the court must evaluate whether a defendant can comply with conditions while released. An evasive answer suggests either uncertainty about recent drug use or an attempt to minimize it. Neither interpretation helps her. Her eventual admission that she probably will not test clean is more credible than her first response, but it comes only after the judge warns that she appeared ready to lie. That timing matters because honesty after being confronted carries less weight than immediate candor. Judge Simpson nevertheless gives her a chance to verify her account through an objective test. The warning about a bench warrant and no bond also removes any possible confusion. She must report, test, and return without delay. Do you think her eventual honesty repaired the damage, or had the hesitation already convinced the judge that closer supervision was necessary?
Your Honor.
This is Senator Davey.
Client here?
She does not appear to be here, Your Honor. I did place a call, but I did not get an answer.
You lost her?
Looks like.
And she did not test?
Your Honor, I received confirmation she did not check in.
It's unfortunate.
Did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh yeah, I remember. We didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections. She's here on campus. She left the building, and I remember her walking out. She said, "I'm going over." We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh, yeah, I know. But it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money, and then had to go to Burger King.
Where does she live?
1282.
So in this county.
Yes,
So when does it 4 hours or
Your Honor.
hours to go home, come back,
3 hours.
and then do that? And I don't know where the Burger King comes in.
It was not 3 hours, Your Honor. I was going 45 minutes. I have my test.
Tell me that.
Please, Your Honor.
Because we called over.
She said she called you when I got there, and I sat for like.
I know. She did.
Oh,
But she did get over in test.
She did come. Yeah.
Yeah. Then she left.
Then she, what, Your Honor? I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had to
Said you put
warrant.
warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was.
Oh my,
You recall.
not what she said. Toby.
Your Honor,
I've not talked. I've turned around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am. If you're going to turn around and start smiling and doing all that, this is not a
I was just at.
bond denied. I'll set it over to July 2nd.
You're not even giving my information.
Keep talking.
This is the decisive credibility collapse. The positive cocaine result confirms recent use, but Judge Simpson's reaction is driven by more than the laboratory finding. Amanda was ordered to travel directly to community corrections and return. Instead, the record now includes a trip home, a stop at Burger King, a substantial delay, and no return before the court issued a no-bond warrant. Even if she genuinely needed money for the test, that explanation does not account for every detour or her failure to communicate promptly with the court. Her strategy then becomes especially damaging. She insists that she had already warned someone the test might be positive. But Judge Simpson distinguishes what she allegedly told her probation officer from what she told him in court. That distinction is legally important because a defendant cannot cure a misleading statement to the judge by pointing to a more candid statement made elsewhere. When she turns, smiles, and continues talking after being told to stop, the judge interprets that courtroom conduct as further evidence that she is not taking the bond conditions seriously. Was bond denied simply because of the positive test, or because the delay, contradiction, and demeanor collectively showed that less restrictive conditions could not be trusted?
All right.
State your name for the record, please.
Xavier Bonner. What are we doing?
Your Honor, I'd like to ask that the PCC be set over to the 9th. I also understand there's a probation violation because he didn't get tested. I've talked to him.
It's not only that he didn't get tested, he didn't even report. I wasn't aware.
I don't know that Mr. Amadeo was his attorney at that time, Your Honor. I have made sure that he's going to. His mother is here with him today, and I'd like to adjourn the violation over to the 9th. I've made very clear to him that he's got to report this morning.
When he was arraigned, he was told to go over.
Well, I was not present. I'm just indicating to the court that I've told him very emphatically his mother is here. He's going this morning.
Okay, is he saying he didn't know? Is that what he's representing to the court? Because he needs to be careful if that's what he's representing.
I don't understand.
No, I did.
Tell the judge.
I didn't understand. Prepare new orders. Is he working? What are you doing when you're out?
I work at McDonald's. Well, who else?
How long have you worked there?
For like 5 months.
He lives with his mother and I believe his sister, Your Honor. And they're both here in the courtroom. His mother's here in the courtroom with him.
We'll prepare a new order for community corrections. You need to go over there before you leave this complex. You understand that?
Understand.
And so I want that order and an order for a GPS tracking location tether. And then I will adjourn this to July 9th, 2026, 9 a.m.
I'm sorry. I didn't hear when, Your Honor.
The 9th,
Thank you, Your Honor.
10 a.m. Bond continued with those added conditions.
Thank you, Your Honor.
These hearings show how Judge Simpson separates a violation that destroys trust from one that may still be managed through stricter supervision. Amanda James admitted recent drug use, tested positive for cocaine, failed to complete the court's instruction in the expected sequence, and then argued with the judge about what she had previously disclosed. The court therefore kept her bond denied and adjourned the matter to July 2nd. Legally, that ruling reflects a forward-looking assessment. Can the court reasonably expect this defendant to obey release conditions when her first opportunity produced delay, contradiction, and resistance? The second defendant also failed to comply. He did not report or test after arraignment, but his attorney offered a different risk management proposal. Counsel did not attempt to excuse the failure outright. Instead, he emphasized that the defendant's mother was present, that he had employment at McDonald's, and that he would report that morning. Judge Simpson responded with graduated restrictions, a renewed community corrections order, GPS location monitoring, continued bond, and an adjournment to July 9th. That is not forgiveness. It is conditional liberty backed by increased surveillance. The broader lesson is that bond hearings often turn on credibility, immediate compliance, and whether a practical supervision plan can reduce the court's concerns. A violation does not always produce the same result because judges evaluate the full pattern, the explanation, and the defendant's response when challenged. Which defendant gave the court more reason to believe future orders would be followed? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.